morning, Your Honors. My name is John Burleson. I'm a member of the Madison County Bar. I'm here on behalf of the appellant, City of Germantown, in this matter that's on appeal from Shelby Chancery. Your Honors, there are really...
Rebuttal time, Mr. Burleson?
Oh, yes, sir. I want to reserve, let me reserve 3 minutes for rebuttal, please.
3 minutes. I know age probably affects...
I won't argue with you, Your Honor. That's all I can say. Your Honors, we're dealing with an issue on whether some property, use of a property is for a non-conforming use. It's on Poplar Avenue. There are 3 addresses involved, but it's really 2 parcels of land. One is 7092 Poplar Avenue. That issue was litigated in circuit court, and judgment was entered back in 1993 by Judge Lanier. We're here today on the issue regarding 7038 and 7040 Poplar. A little factual history that is important. I think the key unrefuted facts that are important, since this is a summary judgment issue, is these 3 addresses back in 1955 were used to operate a commercial nursery. And the significance of that is, at that point in time, in 1955, the property was in the county, but it was annexed by the City of Germantown. It was zoned commercial, and so the use of the commercial nursery was appropriate at that time. In 1957, Germantown amended or changed the zoning from commercial to residential. The property in 1957 continued to be used as a commercial nursery. And of course, that was a non-conforming use that was protected by statute, and the property owner had the right to continue operation in that manner, period. Now, we move forward, fast forward to the present, and this property continues to be used as a commercial nursery. Now, in the interim, there have been things that have happened, but in terms of purposes for summary judgment, as we've set forth in our brief, the key date as to determine what the non-conforming use is what was that property used for in 1957, when the zoning was changed from commercial to residential, and that is as a commercial nursery. Now, we've raised 2 basic issues in this case that are up on appeal. The first is more of a procedural issue, and that we think that it was error to deny our motion on this matter, that this matter is not ripe yet to be decided by the court. The City of Germantown has not had an opportunity to respond to the plaintiff's request. Now, the appellee's request. The appellee, Mr. Trezevant, now owns the property, and he is proposing to convert it to commercial office space. On 7092, there would be an 11,000 square foot office building. That's not at issue in this case. And then there's a 45,000 square foot office building proposed for 7038 and 7040 Poplar. The argument is that that is a non-conforming use protected by statute 10 Code Ann section 13-7-2.
Why is the one piece of property not at issue at this juncture?
Well, Your Honor, good question. Here, the 7092 has already been litigated. That was litigated in 1993. And so we're talking about a different piece of property, a different parcel now.
We don't even need to be concerned with that piece of property for purposes of our analysis.
Yes, sir, I agree with that. And it's very clear in the stipulations. Now, that happened a long time ago, 1993. It was different lawyers, different judges. But the parties entered written stipulation that said that litigation applied only to 7092 Poplar. It didn't have anything to do with 7038 Poplar or 7040 Poplar. Now, I think the appellee would like to make it all one piece of property, but it's different litigation. And I can address that if you want me to. I think as I understand the argument, is that under the statute, they would like to say that this is a continuous use of the property, and so they would like to use Judge Lanier's ruling on the property at issue today. But the issues are totally different. The only party the same as City of Germantown. Mr. Trezevant wasn't a party. This proposed office use was not even in existence until 2021. So that litigation is totally different than this. It's a totally different universe of facts and totally different issues as time has passed and things have changed. And in terms of the procedural side of this case, the city, the appellee is required to file a building permit and to go through processes with the city before the Board of Zoning Appeals, Design Review Commission, et cetera. There's procedures, and we've made those procedures, attached it to our brief. I think it's Appendix C. He's never done that. And what he says is, well, I'm required to do engineering drawings, and I don't want to spend the money. So, Chancery Court, I want you to tell the city they have to treat this as a non-conforming use, and then I'll submit the application. Well, he doesn't know what the city, none of us know what the city is going to do with the application.
Well, let me follow that logic that you
Yes,
just alluded to. If the Chancery Court, as it has done, has said, basically, this is a non-conforming use, what would be the purpose of submitting an application to the city?
Well, Your Honor, first of all,
Assuming this is upheld.
could you repeat that, Your Honor?
I know it was pretty confusing, wasn't it?
Yeah, I just want to make sure I understand what
Assuming
you're saying.
we affirm what the Chancery Court has done, what would be the purpose in submitting an application?
I got you. Well, there's still requirements that the appellee would have to meet in terms of parking, setback, landscaping, size of the building. There's a lot of regulations that would have to be complied with. But that's part of the process of the application that any citizen would have to go through if they want to propose a use of property. They've got to go through the process with the city. And the appellee has asked the courts to say, well, we're presuming the city's going to say that it's not a non-conforming use and that we can't do it. But the city hasn't spoken. They're relying on a 2005 letter from the city attorney at the time in which the city attorney expressed an opinion that he was doubtful that the mayor and board of aldermen would approve it. But he's a city attorney. He's not the city. And then they rely on an affidavit from a city official, I think he was director of community development, a 2011 affidavit saying that he expressing doubt that the city would approve it. And they may be right. But when those opinions were expressed, there was no plan for this office building. That was not submitted until 2021. So we're getting the cart before the horse. We need to let the city speak, and then the issue's ripe for a decision. So that's one premise. But then in terms of the substantive...
The
yes,
entire packet has to be submitted to the
yes,
city.
Yes, sir. And part of that process is to determine if the zoning is appropriate. And so that's part of the process that anybody in Germantown that wants to develop property has to go through. But the appellee wants to exempt himself from that and say he doesn't have to do that. And that's where we say the law does not support that. And I've raised it and I've briefed it.
Does the city have an option to bifurcate that process? In other words, could they decide piecemeal whether this was a conforming use or non-conforming use?
Could the city do that?
Yes.
You know, Your Honor, I'll be frank with you. I don't know if under the city ordinances if that's a possibility or not. Okay. That's maybe something that could be considered, but I really can't answer that question, at least not definitively. And Your Honors, I've raised in our brief the fact that if this matter is a matter of legal controversy, it should be viewed as a writ under a writ of certiorari, because it's an administrative decision. It's not a declaratory judgment action. But we've briefed that, and I think the key issue under whether it's a DJ or writ of certiorari is the issue's not ripe. But in terms of substantive law, whether it's a non-conforming use or not, if you look at the statute, now the courts have told us that the statute is to be strictly construed against the party who is asserting the exception of having a non-conforming use. And if there's any ambiguity, which I don't think there is in this case, but if there is, it's to be the municipality, the governmental entity, is to get the benefit of the doubt. And Your Honors, what we have here is the statute tells us The non-conforming use is what was this property used for in 1957? It was used for commercial nursery. The statute says it, the language, I've cited it for you in the brief. I'm glad to cite it here if you want me to, but it talks about the conduct of the business at that time. And it was a commercial nursery. And clearly operating, changing, calling, and Mr. Trezevant's been deposed. It's unrefuted, it's unequivocal. He says, if this is granted, I'm going to destroy the nursery and I'm going to put in commercial office space. That is not a non-conforming use under the statute. And there's potentially two subparagraphs under the statute. It's either B1 or C. And neither one of these fits. The use was a commercial nursery. Mr. Trezevant is trying to argue that instead, he's broadening the definition of what a non-conforming use is from 1957, that he uses the term commercial. If it's commercial, then it was a commercial nursery. It's commercial being a real estate, office space that is for rent to a third party. That's not what the law is. It's not what the statutory language supports. That's not what the case law that this court has ruled on supports. We've given you several cases in our brief that clearly hold for the proposition that the use at the time of the rezoning is what controls and defines the non-conforming use. The Lafferty case is one. The Ryan case, the Lafferty case was a case about a bed and breakfast that had actually built and constructed a pub after a rezoning, and that was found to be a non-conforming use because the bed and breakfast was still there, but the pub was a different business, a different use, and clearly the court said you look at what it was at the time of the rezoning. There's another case, Ryan versus Metro, we've cited in the brief, that deals with an ice cream parlor. The same proposition of law stands there. An ice cream parlor had been located at a building at one point in time, but when the area was rezoned, it had been used as a retail space. The owner later, after the rezoning, tried to have it as a non-conforming use, and the court said no, it was not used as an ice cream parlor at the time of the rezoning. I see that my time is up. Thank you.
Thank you. You've still got your rebuttal time.
Thank you, Your Honor.
Good morning, Your Honors.
Morning.
Lou Wardlaw of the Memphis Bar for Trezevant Enterprises, Inc. Trezevant has for decades sought to build offices on the property at 7038 and 7040 Poplar Avenue to match the legally recognized rights that exist on 7040. Each of these properties has street number designations, as is common, but as was conceded by counsel in his opening statements to you, the properties have all been used together since well prior to 1955. Germantown has consistently and throughout this case and well prior rejected Trezevant's use of the property for anything other than a nursery. There were some questions, Judge Stafford, about the process that you have to go through to do this. And Germantown gets to write the rules and the planning and the zoning protocols that govern its community. But those rules are subject to Tennessee statutory and common law. And the role of all government, including that of Germantown, is to follow that law and not exceed their authority. We respectfully submit that Germantown has violated that rule. To that end, this matter was never before the Chancery Court on petition for writ of certiorari. It's not before this court on petition for writ of certiorari. It was there on declaratory judgment and remains that way. Trezevant sought an acknowledgement of its rights to proceed under the grandfather statute. In effect, avoiding a bifurcated no. If Trezevant applies to the city of Germantown, having been told that they cannot do what they want to do, and Germantown says you can't do it, we're not going to let you do it, and hides the ball in any way, says because the doors are too tall, there's not enough parking, you're denied, then you're stuck. Then you're on writ of certiorari. Trezevant sought an acknowledgement under the Declaratory Judgment Act to get the playing field set. And I'm going to go into that a little bit more. Since 2005, and even before, but the first time in the record, since 2005, Germantown has rejected Trezevant's right to improve the property as it wants to. As has been fully briefed and is cited by counsel, then city attorney for the city of Germantown, their highest lawyer, sent a letter to Trezevant's then lawyer, Rick Winchester, concluding that it is clear that such a leasing of office space is not a permitted use. With that opposition, Germantown and Trezevant had a formal disagreement over Trezevant's rights. Trezevant then chose to address the Chancery Court and its rights under the Declaratory Judgment Act to relieve, and this is the quote from the statute, uncertainty and insecurity as to the rights of both parties. Ultimately, the Chancery Court agreed with Trezevant's position, and we asked this court to do the same.
So you've got an administrative process that's set up, correct? Theoretically applies to everybody. What allows your client to bypass that administrative process?
They're not bypassing at all, Your Honor. They're seeking to set the playing field in that process. It's exactly what the Declaratory Judgment Act talks about. It talks in terms, and you probably see it from this bench more, in terms of contract disputes, contract uncertainty, and the like. I don't think I owe this bill. I may owe this bill, but I'd like a court to tell me before we fight about it. But it also talks about, and this court has allowed it to talk in terms of zoning rights and property rights. So Trezevant went forth under that Declaratory Judgment Act.
Well, let's stop before we get there. I know what Trezevant did. What I'm trying to figure out is why Trezevant did not follow the administrative process.
Because they had been told by the city's attorney on the front end, no.
That's not what you read to me a moment ago.
I respectfully push back, Your Honor.
Well, I appreciate
There is no
that.
way that Mr. Cates' letter can be read in any way other than saying no. He
So
uses
is
the word
still
clearly.
City attorney?
Mr. Cates, is he still the city attorney?
Yes.
No, he's sadly passed and
So how do we know what the new city attorney or the new administration or anybody who works in that office, how do we know what they would do with a application at this juncture?
Well, we do know from the city of Germantown's own briefing during this litigation that the municipality's position to deny a building permit must be reviewed on petition for writ of certiorari. We do know from their own briefing, let me find it in my notes so I don't misquote from it, that from the inception of the litigation, Germantown has sought to maintain that this property only be used as a nursery. That's from their words from their counsel during the litigation. We do know from Jerry Cook's affidavit that he said the Board of Mayor and Aldermen want this to only be residential. We do know after the plans were submitted in 2021 as ordered by the Chancery Court, we do know that Germantown said, we will not meet with you until you give engineered plans. What Trezevant was seeking...
Is that not what would be required of any applicant? I'm trying to ascertain if you're being treated differently here. I'm trying to figure out why you can do what you're doing and everybody else is required to follow the administrative process.
And I think that slightly misstates the question, Judge Stafford.
That's my question, though.
But I'll answer your question.
Okay.
Trezevant does not get to bypass the administrative process. Trezevant has to go through the administrative process. Counsel was absolutely correct. Parking, aesthetics, wall heights, materials, all of that is subject to review and approval by the city of Germantown. What Trezevant wants is to have the playing field on which that process is determined, decided. Because Germantown has said, we submit, in at least 4 different avenues during this case, no, it's a nursery, it's only a nursery. they were cited to the case that was before Judge Lanier in 1995. That's on the 7092 parcel, which council has said, and the proof shows, all originated as the same use. It was all a combined and intermingled use. At that point, Germantown proactively sued Trezevant's predecessor, Norman Brown, who has also since passed away, and the pest control business that operated on the property, saying, no, you cannot operate this as anything other than a nursery. And they lost that case. The stipulations in that case and the findings by Judge Lanier in that case very clearly found that this was one intermingled, intertwined piece of property. The only property that was before Judge Lanier specifically as far as a ruling was the 1792, because that was artificially designated in the lawsuit by the city of Germantown. Had they sued on all three of the municipally designated street addresses, we suspect that the answer would have been the same, given the underlying stipulations and given the ruling of Judge Lanier. But they chose to artificially sue on only the one of them, and they lost it. So not only is there Thomas Cates' letter and Jerry Cook's affidavit and the briefing within this case that no, you can never use it for anything other than a nursery, there was also the prior, Germantown is standing behind the shield now, but they stood behind the sword at that time and said, no, this is a nursery and it will always be a nursery. And they were wrong, and we submit they're wrong again now. The stipulations in that case, and Germantown seeks to distance themselves from them in their briefing, but they've stipulated in this case that all of these properties stem from the same Neshoba plantation tract. Those deeds are stipulated to and heavily cited in my briefing, and I won't go over them again. But Judge Stafford, we're not trying to overstep the process or bypass the process. We're trying to set the playing field using the two statutes. The one that I think it gives us an absolute right to do it is the Declaratory Judgment Act, saying we have a dispute, there's a clear dispute, that dispute is right. Tell us the playing field on which we apply. There is no zoning designation for nursery, but were a commercial office designation also allowed on this property, they would then go forward with the application process, get thumbs up, get thumbs down, maybe litigation, maybe not, do whatever. We say, and our briefing says, and the Chancery Court agreed, that in utilizing our rights under the grandfather statute, that should be read into that process, and that Germantown doesn't have the right to proactively say, no, do anything you want to, but it'll never be anything from a nursery. And that's what they've done.
Mr. Wardlow, let me ask you a question. You say you're trying to level the playing field, but what you're doing, it seems to me, is asking for an ultimate answer on whether you can build this building. And isn't that what the building zoning or the application process through the city is for, is to answer that question?
And let me answer that exactly to your question, Judge McGee. We're not trying to level the playing field. We're trying to discern the playing field, set the playing field, define the playing field.
Well, you can call it what you want to, but it looks like you're just trying to get an answer to whether you can build a building, and you want to take that answer definitively and then move forward in your process.
We're not trying to get a determinative answer on whether or not we can build this building, the plans that were submitted in 2021.
Aren't you trying to get an answer of whether you can build a commercial office building there?
Offices for commercial use, offices to be rented to somebody else.
As Judge McGee said, isn't that what the whole administrative process is about?
No, I don't think it is. The administrative process is to follow the law, including the grandfather statute. They could then, if we have a determination,
but you can present all that to the administrative agency.
I didn't hear you, Your Honor. I'm sorry.
You can present all the information that you're talking about now to the administrative agency and get a thumbs up or thumbs down, as you said a moment ago.
I think then I will adopt the language of leveling the playing field. I do think that changes it. If Germantown is allowed to preemptively say on the front end, in writing, with no mistake, we're not going to let you build anything other than a nursery, then to do that in the face of that is a violative of the grandfather statute, but then puts Trezevant Enterprises in an unfair position. And I think that is exactly the point. I
Well,
think
you can resort to the courts just as you've resorted to the courts here.
taking that logic, Your Honor, to its full conclusion, then I fail to see why or for what reason the Declaratory Judgment Act would it all allow the bringing in a zoning context, which this court has found is appropriate, in a zoning context, why it would allow to bring to the court at all a question about a determination of rights to get rid of that insecurity and uncertainty. I don't see that. I think it would be redundant in that effect and would take uncertainty such that Trezevant faces out of the realm of a Declaratory Judgment Act. So we did exactly that and went forward under that. And given the commonality of the property, the commonality of the uses, the commonality of the source of the properties, it's our firm position that this would be allowed for much more than a nursery. We're not asking for much more than a nursery. We're asking for offices to be used to be rented to third persons. This case had come before Chancellor Armstrong several times. It's a long case. It's been going on for a very long time. It had come before him. He looked at Judge Lanier's ruling, and he said that there's a commonality of this property. Joe Day Jenkins looked at Judge Lanier's ruling, looked at the facts, looked at the stipulated deeds on the sources of the property, and said that there's a commonality, and that this should be an allowed use. No judge, not Chancellor Armstrong, not Chancellor Jenkins.
Are you saying Chancellor Armstrong said this should be an allowed use?
Chancellor Armstrong said specifically, to the extent that Judge Lanier's opinion, which was never appealed, makes a determination that a permissible use of office space is renting to others, and that decision was not appealed, I mean, you're kind of stuck with it, aren't you, saying that to the City of Germantown's council? I think he has decided the issue, that he can have office space that's rented to others. Yes, Your Honor, I do believe that Chancellor Armstrong
Was he
said
talking
exactly that.
about more than the one area that, or the one parcel that Judge Lanier had previously ruled on?
I think so, yes, Your Honor. He determined immediately after those prior statements, I gather from this opinion and from what I know, that apparently this must all have been one tract. And he didn't know that in a vacuum. He knew that because that's in the record in this case, including the deeds that show that all of these properties, however they were assigned an address, come from the same tract.
Didn't he go on and say, submit the application?
No, Your Honor,
Didn't
he did
say
not.
that.
He did not say that. He said, I need to know something more about what you intend to build. He said, and I'd like to quote him as specifically, the dispositive motion was not well taken, should be denied, and the case should be stayed pending the plaintiff filing with the court specific written plans for the use of the subject property. Not an application, not engineered drawings, a specific written plan, which shows, we've shown, a two-building complex that does cross over both the 7092, 7038, 7040 properties, and shows definitively it would be office space to be rented to others. And on that, even though that exactly meets the
Used your
requirement.
time.
Thank you, Your Honor. Thank you,
you.
judges.
Your Honors, just a
I think
few
you got 2
comments.
minutes.
I think there's a real strong policy consideration that is at play here in terms of the Court of Appeals and courts have shown judicial restraint and have stated that explicitly many times through the years in cases in the decision-making processes of governmental entities. And from the city's perspective here, I think what the appellee is doing is asking the court to perform the city's function of the administrative function, reviewing this to determine if it's a non-conforming use, if it's a zoning issue or not. And I think based upon the decisions of this court in the past, it would be a mistake. It could open up Pandora's box to the courts. Anybody that doesn't like a city process, well, I'm just going to file a DJ action and ask the court to tell the city or tell the county this is what they've got to do, this is the way it's interpreted. So it's a slippery slope and a dangerous game. Mr. Trezevant hadn't been injured yet. He doesn't have an answer from the city. And so that's why this matter is, it's premature, it's not ripe. This matter should be reversed, and Mr. Trezevant needs to go through the process that any other John Q. public citizen would have to do to develop property in Germantown. And also, Your Honors, I did not hear anything in the argument from counsel that refuted or went against the idea that I think is clearly the law under the statute and under the case law, that the nonconforming use, if you get to the substantive issue, the nonconforming use was what was the property used for in 1957. And the use Mr. Trezevant is proposing clearly is in no way related to commercial nursery. It's not a nonconforming use. It's a new use. He needs to go through the city processes. We ask that you reverse this matter, reverse the judge's granting of summary judgment to the appellee, and grant the city's summary judgment in this matter. Thank you.
Thank you. Thank you, counsel. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. Thank you. You may be excused. As the next case is moving up, we're going to take a brief recess and